Okay. Resume today at Ibadan, Monday, 2nd June 2025. Before His Lordship, Honorable Justice Yakubu Mohammed Hassan. Case number 1, case for judgment. Case number NICN/AB/10/2019 between Olubunmi Alaba Oshidowo versus Brooklyn. Okay. 2025. Okay, we should take number 2. Okay, case number 2, case number NICN/IB/50/2021 between Kolawole Taiwo Adediran versus Governing Council, Federal Polytechnic Ado Ekiti.
Part is online. Yes, appearance. Anybody online? Appearance.
My Lord. Good morning, my Lord. My Lord. My Lord.
Please increase your volume.
Increase the volume of your phone.
Babalola. I know that, my Lord. Tosin Babalola for the respondent. Yes, I was waiting for the claimant applicant to announce his appearance.
What of the claimant counsel?
Probably he's trying to join. He's probably trying to join because he informed me that he's outside the court premises this point.
Hello, Barrister. Hello.
Yes. I am online.
Okay, please speak louder.
I'm online. I'm online. Kolawole Taiwo Adediran is my name. My appearance is for the claimant applicant. Can you hear me, sir?
Yes. Appearance.
My Lord,
Appearance.
Tosin.
Kolawole Taiwo Adediran. Yes, sir. Claimant applicant.
Tosin Babalola for defendant respondent.
Yes, Mr. Adediran.
Yes, sir.
Yes, are you Yes.
The matter is for judgment, sir.
Yes.
And we are ready, sir.
Thank you. This is judgment of the claimant filed dispute on 28th day of January 2022 via an originating summons. The claimant submitted the following question for determination, which are following. 1. What are section 17, subsection 1 of the Federal Polytechnic Act, Cap F17, LFN 2004, section 36 and 34 sub 1A of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 11 sub 7 of the Labour Act N1 LFN 2004 and paragraph 6 of the applicant's letter of appointment dated 10/1/2000 issued by the defendant/respondent institution to the applicant are mandatory or permissive for the respondent. 2. The defendant respondent having known vindictively and carelessly refused, failed, and neglected to observe and obey section 17 sub 1 of the Federal Polytechnic Act, Cap F17 LFN 2004, section 36 and 34 sub 1A of the Constitution of the Federal Republic of Nigeria 1999 as amended, section 11 sub 7 of the Labour Act L1 LFN 2004, and paragraph 6 of the applicant's letter of appointment issued by the respondent to the applicant, whether the respondent conduct an act in connection with the fact of this case, and the respondent's institution to the letter issued by the respondent's institution to the applicant dated 9 March 2007 was ultra-variant, null, and void, and same constituted a violation of the applicant's fundamental right to fair hearing, dignity of human person by subjecting the applicant to degrading treatment. C. Whether the said order of the respondent contained in the letter issued by the respondent institution to the applicant dated 9 March 2007 is competent at law. 4. And finally, whether the respondent having acted ultra-variance and violate the applicant's fundamental right to fair hearing and dignity of human person in connection with the fact of this case, the applicant is not entitled to remedies / redress, damages, and compensation. The applicant then pray for the following reliefs. 1. A declaration that section 17 sub 1 of the Federal Polytechnic Act, Cap F17, LFN 2004, section 36 and 34 sub 1A of the Constitution of the Federal Republic of Nigeria 1999 as amended, section 11 sub 7 of the applicant's letter of section 11 sub 7 of the Labour Act Cap L1 LFN 2004 and paragraph 6 of the applicant's letter of employment are mandatory for the respondent. 2. A declaration that the order of the respondent contained in the letter dated 9 March 2007 from the respondent institution to the applicant was ultra-variance, null, and void, and same constituted a violation of the applicant's fundamental right to fair hearing and dignity of human person. 3. A declaration that the conduct and act of the respondent in connection with the fact of this case and the said order of the respondent contained in the letter dated 9 March 2017 from the respondent institution to the applicant was clear and same actually put down the applicant subsequently injured, substantially subsequently injured and the applicant person and diminish the applicant dignity of human person. 4, a declaration that the conduct and act of the respondent in connection with the fact of this case and the respondent order contained in the letter dated 9 March 2007 from the respondent institution to the applicant caused unnecessary discomfort and disruption and career progressing of the applicant. 5, a declaration that the respondent order contained in the letter of the respondent institution to the applicant dated 19 March 2007 is ultra-various and same is not competent at law. 6, a declaration that the applicant is entitled to remedy, damages, and compensation the respondent having committed wrong against him. 7, an order of this honorable court directing the respondent to pay forthwith to the applicant all his accrued salaries, allowances, entitlement, and benefits. Salary scale HATISS 2 step 4 from 9th March 2007 till the date of judgment, and henceforth the respondent having acted ultra-variance and same constituted a breach of the applicant's fundamental right to fair hearing and dignity of his human person. In support of the originating summons is an affidavit of 33 paragraphs deposed by the claimant himself. Attached to the supporting affidavit are annexures marked as Exhibit A1 to C. Equally filed in support of the originating summons is a written address dated the 25th day of January 2022. Upon being served with the originating summons, the defendant filed a motion on notice by way of preliminary objection dated the 25th day of February 2022, but filed on 28th day of February 2022. Also, the defendant filed counter affidavit dated 10th day of March 2022, but filed on 24th day of March 2022 in response to the claimant's originating summons. The claimant filed a further affidavit in response to the defendant counter affidavit to the originating summons. It should be noted that the court has ordered parties to address it in writing on the appropriateness or otherwise of the mode adopted in commencing this suit by the claimant. In compliance with the order of the court, the defendant filed its written address dated 8th day of January 2025, but filed on 9th day of January 2025. The claimant also filed its written address dated 14th day of January 2025 and filed same day. In order to save time and treat this case with dispatch, the ordered written addresses, the motion on notice by way of preliminary objection filed by the defendant were taken together with the substantive suit, i.e. the originating summons. However, since the motion on notice by way of preliminary objection filed by the defendant touches on the jurisdiction of this honorable court, it should be resolved first one way or the other before the other processes, i.e. the order written address and the originating summons will be taken. On that note, I shall consider the motion on notice first. The motion on notice, which was filed by the defendant, was dated the 25th day of February 2022 and filed on 28th day of February 2022. The motion was brought pursuant to Section 2 sub A of the Public Officer Protection Act, Cap 41, LFN 2010, Order 17, Rule 11, National Industrial Court Rules 2017, Order 3, Rule 11, National Industrial Court Rule 2017, Order 7 of the National Industrial Court Enforcement Procedure Rule 2009, Section 254, Sub C of the 1999 Constitution as amended, and the inherent jurisdiction of this honorable court. The defendant applicant herein pray this honorable court for the following orders. 1, an order dismissing or striking out the originating summons of the claimant in its entirety for lack of jurisdiction, same having become statute bar. 2. An order dismissing or striking out the ordination summons of the claimant for not being cognizable under the fundamental right enforcement procedure under the rules of the Honorable Court and for having been filed in violation of the fundamental right enforcement procedure. 3. An order dismissing the claimant's suit for being an abuse of court process. Alternatively, 4. An order transferring the suit to the accurate judicial division in compliance with the rules of this Honorable Court, and for such order or other orders as the Honorable Court may deem fit to make in the circumstances. The grounds upon which the application was predicated are as contained on the face of the motion paper. In support of the motion on notice is 14 paragraph affidavit deposed to by one A.A. Adewumi Ella, a senior officer and a staff in the registry department of the defendant applicant. Equally filed in support of the motion on notice is a written address dated the 24th written address. Learned counsel to the defendant applicant formulated a loan issue for determination, which is thus: whether or not the claimant ordinating summons dated the 25th January 2022 as initiated is competent to vest jurisdiction on the Honorable Court, same having been filed without the leave of the court and concurrently with the claimant originating application dated 19 August 2022, same having become statute bar, same not being cognizable under the fundamental right enforcement procedure rule, under the rules of the Honorable Court, and for having been filed in violation of the fundamental right enforcement procedure rule, and same issues having been decided between the parties in the judgment of the Federal High Court of Nigeria, Ado Ekiti, Judicial Division on Wednesday, 2nd day of March 2011 in suit number FHC/IB/SC/12/2010. The submission of the defendant counsel is contained. I shall skip it because of time. Finally, counsel urged the court to dismiss, strike out the suit or claim of the claimant in its entirety and refuse the prayer in the interest of justice. On the other hand, the claimant responded in opposition to the motion on notice filed 19 paragraph counter affidavit deposed to by the Adediran Kolawole Taiwo, the applicant in the substantive suit. Attached to the counter affidavit are annexures marked as exhibit PWTA and PWTB. Filed alongside the counter affidavit is a written address dated the 23rd day of March 2022. In the said written address, counsel to the claimant respondent distilled also a loan issue for determination, which is whether, considering the facts and circumstances of this case and extant law, the Honorable Court has the jurisdiction to hear and grant the relief sought by the applicant in the originating summons and refuse the defendant's preliminary objection to the originating summons. The argument on this issue is also captured. I will also skip it because of time. Finally, and to this end, claimant respondent urged the court in the interest of justice to grant the relief by the claimant in his originating summons and refuse the defendant's preliminary objection to the originating summons for lacking in merit. Court decision. I have carefully perused the motion on notice, the relief sought, the supporting affidavit, and written address in support. I have equally gone through the counter affidavit in opposition to the motion on notice, the annexures attached therewith, and the written address in support of the counter affidavit. Having done all this, it is my humble view that the issue for determination is whether the defendant applicant herein made out a case for the grant of this application. It is important to note at the onset that the garment of the defendant applicant application can be seen from the grounds upon which same was predicated is principally that this suit is statute bar, having been filed outside the limitation period allowed by Section 2 sub A of the Public Officer Protection Act, Cap 41 LFN 2010. Nevertheless, other grounds upon which the application or the motion of notice was predicated will be considered, if need be, after the statute bar is considered. It is worthy of note that the issue of statute bar is one that touches on the jurisdiction of this honorable court, which must be resolved first to determine whether the court has jurisdiction to proceed to decide the suit on its merits. In other words, the issue of jurisdiction, when raised, the court is duty-bound to resolve same before proceeding further. Having said this, it is settled law that jurisdiction is the authority of the court to adjudicate over the question that gave rise to the cause of action. It is fundamental and stressful issue, being the lifeblood and bedrock of all trials. Without jurisdiction, no doubt the trial will amount to an exercise in futility and a nullity. In this respect, see the cases of Okoluwao versus Okoluwao, citation provided, GTB versus Toye, citation provided, and Odum versus PDP, citation provided. Furthermore, a court is only competent to entertain a case when the subject matter of the case is within its jurisdiction. There is no fixture in the case which prevents the court from exercising its jurisdiction, and the case comes before the court initiated by due process of law upon the fulfillment of any condition precedent to the exercise of the jurisdiction. In this respect, also see the case of Madukulo versus Inkem Delim, citation provided, Oloru Rende versus Yunusa, citation captured, and Hope Democratic Party versus Obi, citation provided. It is equally settled law that a cause of action is said to be statute bar if in respect of its proceeding, it cannot be brought because the period laid down by the limitation Company Limited versus Aberi, citation provided, Forestry Research Institute of Nigeria versus Gold. Citation provided. In the supporting affidavit, Particle 8 and 9, which for ease of reference, I shall reproduce him here on that. Paragraph 5 read thus, and I quote, that after a careful perusal of the set of reduction processes, I discovered that the claimant prayed the court to notify and void the termination of his employment from the defendant employment in 9 March 2007, end of quote. Paragraph 6 read thus, and I quote, that the period from the 9 March 2007, when the claimant employment was determined by the defendant applicant to the date when the reduction process which initiated this suit was filed is over 14 years, end of quote. Paragraph 7 read thus, and I quote, that the defendant is a person protected by the Public Officer Protection Act, end of quote. Paragraph 8 read thus, and I quote, that the claimant brought this suit outside the 3-month period required to bring actions of this nature against person of the status of the defendant, end of quote. Paragraph 9 read thus, and I quote, that I am also aware of the fact that the claimant had sometime in 2010 instituted a matter similar to the instant suit in fact issued, released, and parties, which was struck out for being statute bar in a court ruling by the Federal High Court, Ado-Ekiti, Judicial Division on 2nd March 2011. in suit number FHC/IB/CB/12/2010 between Mr. Adediran Kolawole Tayo versus the Governing Council, Federal Polytechnic Ado-Ekiti, and 4 others. The said court ruling is hereby attached and marked as Exhibit A. End of quote. In addition, the defendant applicant counsel submitted in their written address at paragraph 0.3.1 to 0.3.9 inter alia that the claimant is barred from proceeding with the claim against the defendant for an act or act done in pursuance or execution of a public duty if it is not commenced within 3 months of the alleged act in view of section 2 sub A of the Public Officer Protection Act. From the above, it is clear as daylight that the argument of the defendant applicant counsel that this suit is statute bar was based on the prohibition of section 2 sub A of the Public Officer Protection Act, cap 41 LFN 2010. Therefore, for clarity and ease of reference, let me reproduce here under the said section 2 sub A of the Public Officer Protection Act. It provides thus, and I quote, where any action, prosecution, or other proceeding is commenced against any person for any act done in pursuance or execution or intended execution of any act or law or of any public duty or authority or in respect of any alleged neglect or default in the execution of any such act, law, duty, authority, A, the action, prosecution, or proceeding shall not lie or be instituted unless it is commenced within 3 months next after the act, neglect, or default complained of, or in the case of continuance of damages or injury within 3 months next after the ceasing thereof. End of quote. This provision is to the effect that any action against a public officer in respect of any act done in pursuance or execution of any act or law or in performance or default in performance or any public duty, authority must be commenced within 3 months from the date of the course of action. Therefore, where the suit is not commenced within the period so prescribed, the claimant's right of action in respect of that cause will be statute bar, and the consequence is that the court will no longer have jurisdiction to entertain the suit. In this respect, see the case of Odu Tan and other versus FIR and other citation provided. It should be noted that hitherto, this court has held that the limitation law did not apply to employment contract. See, for instance, Mr. Victor Omotoshun Ekundayo versus Federal Inland Revenue Service, FIS, and 2 other unreported suit number NICN/ABJ/82/2021, the judgment of which was delivered on 23rd February 2022. This court found support in this stand in the decision of His Lordship, Honorable Justice Ariwola JSC, as he then was, and now later CJN retired, in National Revenue Mobilization, Allocation, and Fiscal Commission, and 2 other versus Ajibola Johnson and 10 other, reported in 2019, 2 Nigeria Weekly Law Report, part 1652, page 245. However, His Lordship Abba Aji JSC in Abubakar Abdul Rahman versus NMPC, reported in 2020, LPLR 55519, decided on June 2020, and Michael Idachaba and other versus University of Agriculture Makurdi and 4 other, decided in 2021, LPLR 53081, decided on 15 January 2021, without reference to National Revenue Mobilization, Allocation, and Fiscal Commission and 2 other, versus Ajibola, Johnson, and 10 other will retreat and hold that limitation law apply to employment contract. Given the rule that in the event of conflict, the most recent of the decision of an appellate court is to be followed, the Court of Appeal in Tertiary Institution, in Tertiary Education Trust Fund, TET Fund, and another versus Dr. Aminu Abdurrahman Anas, reported in 2022, LPLR 58704, per EG will hold that the Supreme Court appears to have moved away from the position it took in National Revenue Mobilization Allocation and Fiscal Commission and 2 other versus Ajibola, Johnson, and 10 other in the recent case of Mr. Michael Idachaba and other versus the University of Agriculture Makurdi and other, reported in 2021, 1 SCM 53 at 64, paragraph 8I. Therefore, so the new law now is binding on this court is that the limitation status apply to contract of service, i.e. employment contract. And once a court hold that a case is statute bar, the remedy is only of dismissal of the case. In this respect, in the case of Aroyemi versus Governor of Edo State and another, citation provided, and Sani versus President, Federal Republic, and another, citation provided. At this juncture, it will be reinstated that the law is settled that in order to determine when a suit is commenced and when a cause of action arose, the court is to look at the originating processes. In this respect, I refer to the case of Frozen Food Nigeria Limited and other versus Estate of Oba Johnson, Agbola, Ojumo, and other, reported in 2022, LPLR 57815, where the Supreme Court, per John Ian Okoro JSC, at page 21 to 22, paragraph A, held thus, and I quote, what the court is enjoined to do ascertain when the cause of action arose, so as to determine whether the action is statute bar or not, is to look at the originating processes filed by the plaintiff, which include list of summons and environment in the settlement of claim, ascertain therefrom when the wrong giving rise to the enforceable claim was allegedly committed, and thereafter comparing it with the date on which the suit was initiated. If the period of persistence of the wrong from the date of accrual therefore exceeds the period of limitation as provided by the statutes, then the suit is statute bar. End of quote. See also the case of Karshi and another versus Giwa and another, citation provided. It is apparent from the academic evidence before the court that there is no dispute between the parties to the fact that the defendant applicant is a public officer within the contemplation of the act. So that being the case, I shall not belabor myself on that any longer. Therefore, in the instant case, a careful perusal of originating summons which showed that in the instant case, a careful perusal of originating summons will show that this suit was filed on 28th day of January 2022, while the course of action arose on 9th March 2007, when the defendant applicant served the claimant respondent a letter of disengagement from his services dated 9 March 2007, attached to the supporting affidavit to the originating summons and marked as Exhibit B. It is therefore clear that this suit was filed outside the 3-month allowed or stipulated by the Public Officer Protection Act. In other words, the claimant respondent did not file this suit until after 14 years or thereabouts, when the cause of action arose over and above the 3-month period allowed by the Act. However, the claimant respondent deposed in his counter affidavit to the motion on notice, particularly at paragraph 8 and 9, which again, for clarity, I shall reproduce same here on that. Paragraph 8 read thus, and I quote, that paragraph 7 and 8 of affidavit in support of the defendant preliminary objection are false, that this suit falls under the exception to Section 2, subsection A, paragraph A of the Public Officer Protection Act, and the defendant is not protected by the said act in the instant case, end of quote. Paragraph 9 reads thus, and I quote, further to paragraph 8 above, the defendant acted outside her constitutional and statutory duty. The defendant acted without good faith. There is a continuing injury being suffered by the claimant in the instant case. That to prove that the defendant did not pay the claimant the 3-month salary in lieu of notice, the claimant attached a mark marked as Exhibit PW1A to PW1B, payment slip of Skybank and claimant retiree severance pay slip from the Office of the Accountant General of the Federation, Abuja, respectively, end of quote. More so, the claimant respondent counsel submitted in the written address, particularly at paragraph 3.7, inter alia, that this suit falls under the exception to Section 2, paragraph A of the Public Officer Protection Act, in that there is continuance of injury being suffered by the claimant in connection with the fact of this case. Let me pause here and refer to the decision of the Court of Appeal in the case of NBC PLC versus Maiba and other, reported in 2013, LPLR 2284A48 by Oyebisi Olayemi Omoleye JCA at pages 26 to 29, paragraph F to B, where it was held thus, and I quote, legal principles are not always inflexible. Indeed, law is organic. This being the case, it keeps growing and sometimes admits certain exceptions. The law of limitation of action recognizes some exceptions. One of such exceptions is that where there had been a continuance of complaint damage, a fresh course of action arises from time to time and as often as damages is caused, end of quote. See also the case of Anyanwu and another versus Nigeria Security Printing and Minting PLC citation provided. Relying on the authority cited above, it is clear that where the act complained of is a continuous one, the course of action is new from time to time. In the instant case, therefore, the major complaint of the claimant respondent is the letter of disengagement served on him by the defendant applicant, disengaging him from their service dated 9 March 2007. This act, in my opinion, is once and not continuous. In other words, the defendant applicant served the claimant respondent the said letter once, and that is all. Consequently, the claimant respondent did not place anything before the court to show or prove that he suffered continuous injury in order for this suit to fall under the exception to the applicability of Section 2 sub A of the Public Officer Protection Act as contemplated. I so hold. To this extent, therefore, the submission of the claimant respondent counsel in their written address in support of the counter affidavit that this suit fall under the exception to Section 2 sub A of the Public Officer Protection Act is, to say the least, misconceived and is hereby discountenanced for not reflecting the true position of the law. To this end, I refer to the case of Hussaini versus Atta, reported in 2023, 8th Nigeria Weekly Law Report, part 1887, page 519 at page 560, paragraph A to C, where Supreme Court held by His Lordship Jauro JAC, delivering the leading judgment thus, and I quote, where a suit is statute bar, the court is prohibited from considering its merit, irrespective of how new the plaintiff complaint may appear to be, as the essence of limitation law is not in the lack of a right of action, but in the extinguishing of that right. It follows, therefore, that no matter how promising the case of the plaintiff may appear to be, once it is the statute bar, it is dead and buried forever. Such a plaintiff is left with an empty cause of action that is rendered unenforceable. End of quote. See also the cases of Aroye versus Governor Edo State, citation provided, and Toyin versus Musa, citation provided. At this point, I cannot go beyond this stage. The claimant indeed has slept over his right for not approaching the court or filing his case within the period allowed by law. The claimant respondent on record is a lawyer. I do not know what kept him this long before he filed this suit. If the case of accrual of cause of action, i.e. 9 March 2007, and the date of institution of this case, i.e. 28th day of January 2022, are compared, it will be seen that it took the claimant respondent 14 years or more to institute this suit. This is clearly in violation of Section 2 sub A of the Public Officer Protection Act. I cannot help. My hands are tied. The law must take its course. In the final analysis, and for all I have been saying above, it is my personal opinion that the claimant respondent suit was not instituted within the period allowed by law. Therefore, the action is statute bar. Consequently, this honorable court lacks the requisite jurisdiction to entertain the suit. To that extent, I hereby resolve the issue for determination in favor of the defendant applicant and against the claimant respondent, and hold very strongly that the defendant applicant has made out a case for the grant of this application. On that note, the application is granted as prey to the extent that the claimant respondent suit is statute bar. Without further ado, I hereby dismiss this suit in its entirety. No order as to cause, judgment is entered accordingly.
Lord, we are indeed very grateful for the well-considered judgment. We pray the Lord will.
Who is speaking?
Taiwa Adedina, sir.
Okay, Mr. Adedina. Yes.
I pray the Lord will continue to increase the knowledge wisdom of my Lord. In the name of Jesus. We are indeed very grateful for the well-considered judgment. May the Lord continue to be with you, sir. Thank you, sir.
My Lord, we are also grateful, my Lord. Tosin Babalola speaking, my Lord.
Yes.
We are grateful for the industry put into the judgment, my Lord. Thank you, my Lord.
Thank you.
Ẹ ṣé o bàbá. Mo ti get it tán. Ntí ẹ̀rọ tó yẹ ti kú báyìí ní òtún. Wọ́n ti give judgment wọn tán. Kò fẹ́ bọ̀ ó ní statute bar.
Case number 2, case for judgment. Case number NICN/AD/10/2019 between Olukunle Alaba and Person Global Technology Limited.
Our part is online. Our part is online.
Watch. Because of the thank God, only the war.
Yes, appearance.
May the court be pleased, my lord.
Yes.
My name is Oluwatosin Olojo. I hold the brief of Emeka for the defendant, my lord.
Oluwa what?
Oluwatosin Olojo.
Can you please spell it, please?
Olojo. Olojo. Oluwatosin. Oluwatosin.
What's your first name?
Oluwatosin is my first name, sir, my lord.
The spell it, please.
Oluwa.
Yes. Yes.
T-O.
C.
T-O. T-O.
Okay, T-O.
Yes, my lord. T-O. S-I-N. S-I-N.
I've got that one. Yes. The surname.
S-I-N. Yes. Then my surname is O-L-O-J-O, my lord. O-L-O-J-O. J-O. Yes, my lord. I hold the brief of Emeka Ekuozo for the defendant, my lord.
I spelled the surname of Emeka.
Emeka. The surname is E-K. W-E.
Come again, please.
E-K.
Yes.
W-E.
Yes.
O-Z.
O-Z.
O-R, my lord.
Okay. You are for who?
For the defendant, my lord. For the defendant, my lord.
No appearance for the claimant?
No.
Is Mr. Isaac online? There's one Isaac about the appearance. Is he online?
I wouldn't know, my lord. I wouldn't know, my lord, if the claimant counsel is online, my lord.
Wouldn't know, thank you. Introductory remark. Olojo.
Yes, my lord. Yes, my lord. Olojo.
Yes. Can you make an introductory remark? The matter is related for what?
But the matter is related for judgment, my lord.
That's what? This is judgment of the court.
That's a purpose.
The claimant hearing by his amended statement of material fact dated the 21st day of February 2022 and filed same date pursuant to the leave of this honorable court granted on the 20th day of February 2022, sought for the following relief against the defendant. 1. A declaration that the summary dismissal of the claimant by the defendant respondent for unsubstantiated allegation of gross misconduct, the relation of duty, compulsive lying, inciting staff against the authority, and generally working against the interest of the defendant company is wrongful, unlawful, unjust, wicked, and offend against the rule of fair hearing and of Section 6 of the office ethic of the defendant. 2. A declaration that the claimant is entitled to payment of all his accused salary, emoluments, allowances, and benefit from the first day of July 2019 until the date of delivery of judgment, and with 15% interest thereon after judgment until payment is made. 3. A declaration that the claimant is entitled to payment of his leave entitlement / bonus in the sum of 126 naira thousand. 4. A declaration that the claimant is entitled to the sum of 54,690 naira being balanced outstanding / accruing on his salary for the month of June 2019. 5. An order directing the defendant to pay the claimant all sums due and payable to the claimant as arrears of salary in the sum of 105 naira per month from first day of July 2019 until judgment is delivered, and interest thereon at 15%. 6. An order directing the defendant to pay the total sum of 105,000 naira per month from the month of July 2019 until judgment is delivered, being claimant's house allowance, transport allowance, and meal subsidy, and interest thereon at 15% after judgment until payment is made. 7. An order directing the defendant to pay the claimant the sum of 162,000, being claimant's arrear of leave bonus and interest thereof at 15%. 8. An order directing the defendant to pay the sum of 759,990 naira to the claimant, being accumulated arrears of pension contribution for 22 months, i.e. September 2017 to June 2019, and the sum of 34,545 naira per month from the month of July 2019 until judgment, together with interest at 15%. 9. An order directing the defendant to pay the sum of 54,690 naira, being the balance outstanding and accruing on the claimant's salary for the month of June 2019. 10. An order directing the defendant to pay the sum of 7 million naira as general damages for wrongful dismissal, which occasions psychological torture, emotional imbalance, trauma, shame, humiliation, mental agony, stress, suffering, and loss of amenity. 11. An order directing the defendant to tender a written apology to the claimant for false and unproven allegations and for wrongful dismissal. 12. An order directing the defendant to reinstate the claimant back to his position / office. 13. An order directing the defendant to pay the sum of 1 million naira as cost of this action. 14. An order directing the defendant to pay the sum of 2 million naira as legal fee to the claimant's legal counsel for legal services in respect of this suit. In response, the defendant filed an amended statement of defense and counterclaim dated the 24th day of February 2022 and filed on 4th March 2022, whereof the defendant counterclaimant claims against the claimant defendant to counterclaim as follows. 1. Judgment in favor of the counterclaimant in the sum of 1 million naira plus interest on the aforesaid sum at the rate of 25% per annum from March 2019 until total liquidation of the said sum, and 10% from the date of judgment until final liquidation of state by the defendant to the counterclaim, being the sum deducted by Yelling Press Limited from the outstanding balance due to the counterclaimant as a result of the defendant to counterclaimant's negligence in the course of his role as production manager of the counterclaimant's company. B. Course of action. In further response, claimant filed amended reply to the defendant's statement of defense and amended defense to counterclaim dated 6th day of June 2022 and filed on 7 June 2022. Also, the defendant counterclaimant filed consequential amended reply to amended defense to counterclaim dated 28th day of June 2022 and filed same day. Upon settlement of pleadings, trial in this suit commenced on 29 April 2024 and was concluded on 23rd July 2024. The claimant and the respondent called 1 witnesses each. At the close of trial, and pursuant to the direction of the court, learned counsel on either side filed their final written addresses. The final written address of the defendant of 32 pages was dated 16th day of August 2024 and filed same day. In it, learned counsel set down 2 issues for determination. To which, 1, whether going by this nature of the claimant's employment with the defendant counterclaimant, this honorable court can hold that the termination of the claimant's employment via letter dated 24th June 2019 was unlawful, null, and void. If no, whether in the circumstances of this case, this honorable court can proceed to reinstate the claimant as the production manager in the defendant counterclaimant's company and grant the other relief sought by the claimant. 2, whether the defendant counterclaimant has established a case of negligence against the claimant to entitle to the relief sought in the counterclaim. Argument on these 2 issues were captured. I shall skip them because of time. Finally, counsel urged the court to uphold the argument canvass hearing in favor of the defendant counterclaimer and enter judgment in its favor while dismissing the claims of the claimant as sought in the amended statement of fact dated 20th January 2022. The final written address of the claimant is dated 3rd day of October 2024 and filed on 16th day of October 2024. In the said final written address, learned counsel to the claimant distilled 4 issues for determination, which are as follows. 1, whether on the pleadings as well as the evidence there are proof of allegation made by the defendant counterclaimant against the claimant to justify his summary and wrongful dismissal. 2, whether based on the fact and evidence before this honorable court, the claimant is entitled to damages and reliefs for his wrongful dismissal. 3, whether based on the fact and evidence before this honorable court, the defendant counterclaimer is entitled to the reliefs in its counterclaim. 4, whether the objection to the admissibility of some documents by the defendant is sustainable in law. The argument on these 4 issues are also captured. I will equally skip them because of time. Finally, counsel urged the court to enter judgment in favor of the claimant as per the relief sought on the amended material statement of fact dated the 21st day of February 2022. The defendant counterclaimant equally filed a reply on point of law dated 20th day of November 2024 and filed on the 22nd day of November 2024. The argument on reply on point of law are also captured. I will equally skip them. Finally, counsel urged the court to enter judgment in favor of the defendant as per the relief sought on the amended statement of defense and counterclaim dated 24th day of February 2022, and discountenancing the submissions contained in the claimant's final written address filed on 16th day of October 2024. Court decision. I have taken my time and studied very carefully the general form of complaint, the amended statement of material facts, the amended statement of defense and counterclaim, the amended defense to counterclaim, the defendant counterclaimant consequential amended reply to amended defense to counterclaim, and other auditing processes. I have also evaluated the entire evidence adduced by the parties, both oral and documentary, and I listened attentively to the testimonies of witnesses called and watched their demeanor closely. In addition, I also heard the oral submissions of learned counsel on either side at the stage of adopting their final written addresses. And I stood the same. Having painstakingly done all this, it is my humble view that the issue for determination distilled by counsel in their respective written addresses can be narrowed into 2, which are: 1, whether the claimant has proved his case as required by law to be entitled to the relief sought. 2, whether the defendant counterclaimer has proved his counterclaim to be entitled to the grant of sale. Before I consider the issue for determination raised above, let me first and foremost resolve some preliminary issues. It is on record that at the trial, when the claimant counsel sought to tender in evidence Guaranty Trust Bank Limited customer statement of account of Osinuo Olubumi Alaba, 6 in number, and premium pension statement, the defendant counsel indicated his objection to the admissibility of the documents, and leave was granted to counsel to incorporate his argument on the objection in the defendant's final written address, and for the claimant counsel to respond accordingly. The argument on the objection are contained in paragraph 3.02 to 3.05 of the defendant's final written address. Learned counsel for the defendant submitted that the Guaranty Trust Bank Limited customer statement of account and premium pension statement are entries in banker's book, and for them to be admissible in evidence, they must comply with section 90(1) paragraph E of the Evidence Act 2021 as amended, and that the documents are computer-generated evidence, which by section 84 of the Evidence Act required a certification of identification, which was not furnished by the claimant during trial. Cases of Dauda versus Federal FRN citation provided, Kubo versus Dixon citation provided, Polaris Bank versus Center Point Travel Agency Limited citation provided, and Saidu versus State citation provided were cited in support of the argument. Counsel consequently urged the court to so hold. In response, counsel to the claimant submitted that the documents are admissible as they already form part of the evidence on the claimant's further statement on oath. I have considered the argument of I have considered the grounds of objection of the defendant counsel to the admissibility of those documents referred above and the response of the claimant counsel. I have perused through the claimant's pleadings. It is clear therein that those documents were pleaded and relevant to the proper determination of this case. Therefore, it is strict law that relevancy is key to admissibility. Having said this, it is my personal opinion that to do justice in this case, those documents should be considered and admitted. In this respect, I refer to section 12, sub 2, paragraph B of the NIC Act 2006, which provides thus, and I quote, subject to this act and rules made thereunder, the court shall be bound by the Evidence Act, but may depart from it in the interest of justice, end of quote. In circumstances and without much ado, I overrule the objection of the defendant counsel to the admissibility of the documents in the interest of justice and admit the document in evidence and mark as follows. 1. Guaranteed Trust Bank customers' statement of account of Oshomuwo Olubumi Alaba as Exhibit P1 to P6, respectively. 2. Premium pension statement as at 12 October 2022 as Exhibit Q. Also, the defendant counsel sought to tender in evidence through CW1 during cross-examination some documents, namely internal memo dated 11 October 2018 and memorandum dated 27 February 2019, and the claimant counsel objected to the admissibility of same, and as well leave was granted to the counsel to address the court on the grounds of subjection at address stage, and for the defendant counsel to respond accordingly. However, and surprisingly, the defendant counsel through DW1 sought to tender the same documents in evidence, and the claimant counsel did not object, and the documents were admitted in evidence and marked as Exhibit N and L, Exhibit M and L, respectively. Therefore, it is my concerned opinion that the objection earlier raised by the claimant counsel on the admissibility of those documents is overtaken by it through DW1 without the claimant counsel objecting to that extent. I do not need to consider the argument of the claimant counsel on same as so hold. Another preliminary issue to be clear is from the record of the court, the claimant counsel filed a process titled Reply on Point of Law in position to defendant address, reply address dated 22nd November 2024. From the date of filing on the said processes, i.e. 24 February 2025, it was filed after the defendant has filed its own final address on the second defendant and served on the claimant. By the rules of this court, where both the claimant and the defendant call witnesses, and at the close of trial, the defendant shall first, within 21 days, file his final written address and serve on the claimant, who also have 21 days to file his own final address, after which the defendant has 7 days to file his reply on point of law. That ends filing of final written addresses. The rules of this honorable court did not contemplate the claimant filing again after the defendant has filed his reply on point of law, because there must be an end to filing of final written addresses. See Order 38, Rule 20, sub 4 of the rules of this honorable court. Consequently, this process filed by the claimant dated the 20th day of November 2024 and filed on 24th February 2025 is unknown to both the rules of this court and the law. To that extent, the said process is hereby discountenanced and expunged from the record of this court in the interest of justice. Now, the cause is clear. I shall proceed to consider the issue for determination. On issue 1, which is whether the claimant has proved his case as required by law to be entitled to the relief sought, let me begin by saying that it is not in dispute that the claimant was employed by the defendant on 5th June 2017 and his appointment was confirmed on 7th December 2017, and he was dismissed on 24th June 2019. The claimant's appointment later, confirmation of appointment, and summary dismissal were tendered and admitted as Exhibit A, B, and C, respectively. This fact appears not to be in dispute. However, in Relief 1 of the amended statement of fact, the claimant herein sought for declaration that his summary dismissal by the defendant for unsubstantiated allegation of gross misconduct, dereliction of duty, compulsive lying, inciting staff against the authority, and generally working against the interests of the defendant company is wrongful, unlawful, unjust, wicked, and offend against the rules of fair hearing and of Section 6 of the Office Ethics of the Defender. In other words, the claimant is saying that his summary dismissal is wrongful and against Section 6 of the Office Ethics of the Defender. Having pointed out this, it is therefore settled principle of law that the burden of proof lies on the party who asserts to prove. To put it differently, he who asserts must prove with credible and admissible evidence. This section 131 of 1 of Evidence Act, and the case of Demanic Nigeria Limited versus Udok and another, citation provided, and Okeke versus Okeke, citation provided, Mustafa and Zarma, citation provided, and in Sifik versus Muna, citation provided. As pointed out earlier, the claimant in this suit is challenging the dismissal of his employment as being wrongful. To this extent, the law is settled that when an employee complains that his employment has been wrongfully dismissed, he bears the onus to place the terms of his contract of employment before the court, and he must prove the manner his terms were breached by the employer. In other words, the claimant in this instant case has a duty to plead, and lead evidence to prove that his dismissal was not done in accordance with the condition of employment in order to be entitled to the relief sought. In this respect, I call in aid the decision of the Supreme Court in the case of Ovivier versus Delta Steel Company Limited, reported in 2023, for Nigeria Weekly Law Report, part 1904, page 230 and 228 to 229, paragraph E to A, where Abba Aji JAC, delivering the leading judgment, held thus, and I quote, "It is settled law that when an employee complains that his employment has been wrongfully terminated, he has the onus first to place before the court the terms of his contract of employment, and second, to prove in what manner the said terms were breached by the employer. It is not in principle for the employer, who is a defendant to an action brought by the employee, to prove any of this." To the cases of Adekule versus UBA PLC, citation provided, WAEC and another versus ICANN, citation provided, Bulong versus Federal College of Education, Ubudu, and another, citation provided, and Amodu versus Amodu, citation provided. Also, the position of law that an employee challenging his dismissal or termination of his employment must plead, prove, and found his case on the condition of service is applicable to both master and servant employment and employment protected by statute. This was the position reached by the Apex Court in Aji versus Chad Basin Development Authority, reported in 2016, All Federation Weekly Law Report, part 824, page 175 at page 190 as follows, and I quote, "Whether one is suing for wrongful dismissal from an employment with statutory flavor or under common law principle of master and servant, the fact of the employment and the terms and conditions of same must not only be pleaded, but must be proved by evidence for a determination of the wrongful nature of his termination or dismissal can be considered by the court." End of quote. It is clear as daylight from the foregoing that the claimant has some hurdles to cross before the court can declare his termination as wrongful, which is that he needs to plead and prove the terms of his employment and how the terms were breached by the defendant when he was dismissed. This simply means that the court can only determine the wrongfulness or otherwise of the dismissal of the claimant from the employment of the defendant based on the terms and conditions of the employment, as same is the bedrock of any employment. Having said this, let me pause here and note that relief 1, 2, 3, and 4 sought by the claimant are declaratory. To that extent, the law is settled that declaratory relief are not granted as a matter of course, nor are they granted on weakness of the defense on the witness of the defendant case. Such relief must be proved by credible and admissible evidence before the claimant can be entitled to the grant of the declaration sought. In this respect, I refer to the case of MNK versus PDP and 3 others reported in 2012 Nigeria Weekly Law Report, part 1315, page 556 at page 590, paragraph A to B, where it was held thus, and I quote, the burden of proof on the plaintiff in establishing the declaratory relief to the satisfaction of the court is quite heavy, in the sense that such declaratory relief are not granted even on admission by the defendant, where the plaintiff fails to establish his own entitlement to the declaration by his own evidence. End of quote. See also the case of Sule versus Abu, citation provided. At the trial, the claimant testified for himself as CW1, adopted his 2 statements on oath as his evidence in chief, and tendered in evidence 13 documents which were admitted and marked as Exhibit A, B, C, D, E, F, P1 to 6 and Q, respectively. From the evidence of the claimant before the court, the claimant stated that the defendant did not comply with Section 6 of the provision of defendant's office ethic. For clarity and ease of reference, let me reproduce here under the position in paragraph 11, 12, 13, and 20 of the claimant's statement of oath. Paragraph 11 reads thus, and I quote, that I never violated any of the defendant policy, procedure, and or work ethic throughout the period of 2 years when I was in the employment of the defendant, and I was never issued any query for gross misconduct, dereliction of duty, lying, incitement of staff working against the interests of the company, and or any other allegation whatsoever to warrant my summary dismissal by the defendant through its group managing director, Adeyemi Nika. And quote, paragraph 12 reads thus, and I quote, that the defendant breached Section 6 of the defendant office ethic, which provide as follows: any member of staff who falls short of the stipulated standard of behavior for the first time shall be verbally warned if he or she will issue a query, and after he or she responded to the query, will be punished and given final warning. And if he or she fails to turn a new leaf, he or she will be relieved of his or her position, and his or her appointment will be terminated. End of quote. Paragraph 13 reads thus, and I quote, that the preliminary procedure for disciplinary action as provided in Section 6 of the Defendant Office Ethic as stated was not complied with before my summary dismissal by the defendant, to which I was not given any verbal or final warning. I was not given any query to respond to. End of quote. Paragraph 20 reads thus, and I quote, that my summary dismissal is unlawful, null and void by reason of the defendant's failure to comply with Section 6 of the provision of their office ethic. End of quote. On the other hand, the defendant in defense of this suit called one witness by name Abimbola Suleiman, an accountant with the defendant who testified as DW1, adopted his statement on oath, 5 documents which were admitted in evidence and marked as Exhibit L to O1 and O2. From the evidence of DW1 before the court as contained in his statement of oath, is to the effect inter alia that the dismissal of the claimant was in line with clause 6 of the office ethics tender. Also, for clarity and ease of reference, I shall reproduce here under paragraph 11, 26 and 28 of DW1 statement oath. Paragraph 11 read thus, and I quote, going by the claimant/defendant to counterclaimant penchant for disobeying the instructions of the management of the defendant counterclaimant company, particularly as it relates to seeking necessary approval before commencement of any production work, the management of the defendant counterclaimant company was left with no option but to verbally warn the claimant/defendant to counterclaim on several occasions between the period of April and July 2018. End of quote. Paragraph 13 reads thus, and I quote, consequently, the defendant counterclaimant was left with no option but to issue a query to the claimant, defendant to counterclaimant through human resource manager on the 11th October 2018. The defendant claimant query of 11 October 2018 reads thus, you were reported by the GMD to have expressly flouted his order to obtain his approval before commencing the reprint of the my bros titles. You are expected to respond within 24 hours of receiving this memo, while disciplinary action should not be taken against you. End of quote. Paragraph 14 reads thus, and I quote, the issuance of the query to the claimant defendant to counterclaimant after the several verbal warning was in line with clause 6 of the office ethics of the defendant counterclaimant company. End of quote. Paragraph 26 reads thus, and I quote, that following the error discovered in the possession of the books printed for Yelim Prince Limited and the loss of 1 million naira only, the defendant counterclaimer had to issue a final warning to the claimant defendant to counterclaimant via a memorandum dated the 27th of February 2019. End of quote. Paragraph 28 reads thus, and I quote, that there was nothing in the defendant counterclaimant code of conduct for members of staff or office ethics that prescribe for an administrative inquiry or panel to investigate the claimant like defendant to counterclaimer before the suspension or dismissal. End of quote. At this juncture, it is of utmost importance to critically examine Exhibit F, office, that is the office ethics, which contain procedure for discipline, particularly at section 6, which provide thus, and I quote, any member of staff who falls short of the stipulated standard of behavior for the first time will be verbally warned. If he or she continues in unsatisfactory conduct, he or she will be issued a query, and after his or her response to the query will be punished and given final warning. If he or she fails to turn a new leaf, he or she will be relieved of his or her position and his or her appointment will be terminated. Any member of staff who steal or fight with anybody in the company premises will be summarily dismissed. End of quote. From the wordings of Exhibit F quoted above, it is clear that it contains procedure for discipline of staff, i.e. verbal warning, issuance of query, response to query, and final warning. From the totality of evidence before the court, it is in evidence that the claimant was verbally warned between the period of April and July 2018. It's also in evidence that the claimant was issued a query as evidence in Exhibit M, and the claimant responded to the said query as shown in Exhibit J. It is also in evidence as well that the claimant was issued with final warning as can be seen in Exhibit L. Therefore, It is my finding that the defendant has complied with the procedure as stated or spelled out in Exhibit F in dismissing the claimant. It should be noted that the defense of the claimant in his reply to the statement of defense inter alia that the query, i.e. Exhibit M, was abandoned because no warning letter or penalty was given to him, and that Exhibit M has no connection with his summary dismissal is not tenable because DW1 stated under cross-examination that the claimant was pardoned. Again, for clarity and ease of reference, I refer to some portion of DW1 statement under cross-examination. Thus, and I quote, question, show him Exhibit M. What is the decision of your company on Exhibit M? Answer, the company pardoned him on that since he tendered his unreserved apology. Question, the apology you said he tendered, is it before this honorable court? Answer, yes. End of quote. At this point, I took a close look at Exhibit J, which is an internal memo dated 15 October 2018 on the subject, reply to query. The last paragraph of the said Exhibit J reads thus, and I quote, at this juncture, I wish to tender my own reserved apology for any inconveniences that my action or inaction might have caused the company. And going forward, all your orders, either expressly or impliedly, will be followed to the latter. End of quote. This goes to show or support the portion of the testimony of DW1 quoted above that the claimant was pardoned after tendering unreserved apology. Similarly, the defense of the claimant in his reply to statement of defense, among other things, that he did not receive query or penalty at any time before summary dismissal in respect of such delay and payment to Yellen Press Limited, and that Exhibit L was not addressed to him alone, and no prior query issued to him and his team before the warning is, to say the least, outside the contemplation of the procedure laid down or spelled out in Exhibit F in respect of discipline. Consequently, the law is as stated in OVA versus Delta Steel Company Limited, Supra, that it is not for the employer who is a defendant in this suit to prove any of those things, i.e., procedure/steps spelled out in Exhibit F. This simply means that the onus is still on the claimant to prove his case, and it does not shift, as the law is equally settled that a claimant seeking for a declaratory relief must succeed on the strength of his own case and not on the witness of the defense. In this respect, in the case of Amodi vs. Ogadi Union, Nigeria, citation provided. It must be echoed here loudly that the court is required to do that. It must be echoed here loudly that what the court is required to do in cases of this nature is simply to examine the terms of employment and or condition of service, which in this instant case are Exhibit A, E, and F, to determine whether the summary dismissal is in compliance with the condition of service. In other words, to determine what manner the said condition of service was breached by the employer. In this respect, I refer to the case of Nigerian Gas Company Limited versus Ofori Shea, reported in 2002, LPLR 11246, where Court of Appeal held thus, and I quote, I should emphasize that a master, as in the case in hand, can terminate the contract of employment with his servant and at any time and for any reason or for no reason at all, provided the terms of contract of employment between them are complied with. The motive which led to an employer to lawfully terminate his servant employment is not normally a relevant factor, and the court will have no business with such motive, but will only give effect to the contract of service between the parties. End of quote. In the light of the foregoing, therefore, as I stated earlier, the defendant in this instant case has complied with Exhibit F in summarily dismissing the claimant. I so hope Before I conclude, let me say that the argument and or submission of the claimant counsel in respect to the issue of international labor standard and international best practices as is led to ILO Convention number 158 of 1982 on termination of employment is a question of fact, as clearly stated in Section 7, subsection 6 of NIC Act 2006, which, for ease of reference, I shall reproduce same here under. It provides thus, and I quote, the court shall, in exercising its jurisdiction or any of the powers covered upon it by this act or any other enactment or law, have due regard to good or international best practice in labor or industrial relation, and what amount to good or international best practice in labor or industrial relation shall be a question of fact. End of quote. Therefore, what amount to good or international best practice in labor or industrial relation, being a question of fact, must be pleaded and evidence led in proof of sin. In the instant case, the claimant neither pleaded it nor laid any evidence on it. Consequently, submission of the claimant counsel on it in the claimant's final written address amount to leading evidence, which the law frowned at. In support of this, I refer to the case of Madubuzi and another versus Mortgages PHB Limited and another, reported 2021, LPLR 53821, where Court of Appeal by Bitrus Garanzama Sanga, JCA, at pages 553 to 54, paragraph F held, citing Supreme Court case of James Chijoke and the state, reported 2021, LPLR 19716. Thus, and I quote, it needs to be reinstated that submissions of counsel, however beautiful or enticing, cannot take the place of evidence and cannot be the basis upon which an appeal will be decided. End of quote. To that extent, submission of the learned counsel to the claimant in that regard is hereby discountenanced. To this end, therefore, it is my considered opinion, based on the foregoing, that the claimant has failed to adduce credible evidence to be entitled to the declaratory relief sought. I so hope, to that extent, and without much ado, other reliefs sought by the claimant herein are dependent on the survival of the declaratory relief sought, and same having failed for lack of credible evidence, the other reliefs have equally failed as well. On that note, I hereby resolve issue 1 in favor of defendant against the claimant and hold very strongly that the claimant has failed to prove his case as required by law to be entitled to the relief sought. That takes me to issue 2, which is whether the defendant counterclaimant has proved his counterclaim to be entitled to the grant of sale. The defendant counterclaim against the claimant, defendant to counterclaim as follows. 1. Judgment in favor of the counterclaimer in the sum of 1 million naira only, plus interest on the aforesaid sum at the rate of 25% per annum from March 2019 until total liquidation of same sum, and 10% from the date of judgment and until final liquidation of same by the defendant to counterclaimer, being the sum deducted by Yelling Press Limited from the outstanding balance due to the counterclaimer as a result of the defendant to counterclaimer's negligence in the course of his role as possession manager of the counterclaimer's company. 2. Course of action. It should be noted, it should be borne in mind at the onset that the law is settled that a counterclaim is a separate suit from the main claim before the court. And to succeed, the counterclaimer must adduce credible evidence to prove his counterclaim to the satisfaction of the court. In this respect, see the cases of NBC PLC versus ICPO, citation provided, and Tattoo versus Estate of late Alhaji I. Adamu, citation provided. Having said this, it is clear from the pleadings of the counterclaimer, that the counterclaim against the claimant defendant to counterclaim is rooted on negligence. In other words, the counterclaimant alleged that the defendant to counterclaim was negligent in discharging his duty as a production manager, which led to the counterclaimer losing the sum of 1 million naira to one of his clients, i.e. Yellen Press Limited. Therefore, the burden of proof lies on the counterclaimant to prove his allegation of negligence against the claimant defendant to counterclaim. DW1 stated in his statement on oath, particularly at paragraph 17, 18, 19, 20, and 21. For clarity, I shall reproduce them here under. Paragraph 17 reads thus, and I quote, despite the pardon of the defendant counterclaimant company, the claimant defendant to counterclaim continued to carry out his duty in a rather unserious and negligent manner, leading to the defendant counterclaimant suffering losses and incurring avoidable and unnecessary expenses. End of quote. Paragraph 18 reads thus, and I quote, as a result of the claimant defendant to counterclaimant negligence in his duty and responsibility as production manager, the defendant counterclaimant was unable to deliver the books to Yellen Press Limited within the 8 days period as contracted between Yellen Press Limited and defendant to counterclaimant company. End of quote. Paragraph 19 reads thus, and I quote, that as a result of the claimant defendant to counterclaim negligence, the defendant counterclaimant was only able to deliver the books to Yellen Press Limited on the 17th March 2019, which they threatened to reject and return to the defendant counterclaimant company via several telephone conversations with the defendant counterclaimant's group managing director. End of quote. Paragraph 20 reads thus, and I quote, to prevent a situation where Yellen Press Limited will reject the books outright, outrightly, the defendant counterclaimant by an electronic mail of 19 March 2019 was forced to propose a 5% discount from its outstanding balance due from Yellen Press Limited as compensation to Yellen Press Limited because of the delay which was caused by the negligence of the claimant defendant to counterclaim. End of quote. Paragraph 21 reads thus, and I quote, that as a result of the claimant defendant to counterclaim negligence, the defendant counterclaimant suffered a loss of 1 million naira, being the amount deducted by Yellen Press Limited from the outstanding balance due to the defendant. End of quote. The counterclaimant tender in evidence exhibit N. From the evidence of the counterclaimant through DW1 reproduced above, it is clear that the counterclaimant led evidence that they suffer a loss of 1 million naira as a result of the claimant counterclaimant, as a result of the defendant counterclaimant negligence to ensure that the defendant counterclaimant's machine and printing equipment were in good condition and were serviced, as well as ensure that there were adequate raw material to cover the job which the defendant counterclaimant company had contracted with Yellen Press Limited. However, the claimant defendant to counterclaim in his defense stated in his further statement on oath, particularly at paragraph 6, 13, 14, 15, and 16. Again, I shall also reproduce them here under ease of reference. Paragraph 6 reads thus, that I discharge all my duties and responsibility as production manager of the defendant completely, diligently, and with utmost care and skill. Paragraph 6, end of quote. Paragraph 6, figure 4, read thus, and I quote, that I am not the store officer of the defendant, end of quote. Paragraph 6, figure 5, read thus, and I quote, that it was the exclusive duty of the store officer and not myself to ensure that there is no stock out of material and consumable required for printing job, end of quote. Paragraph 6, read, figure 6, read thus, and I quote, that Mr. Taiwo Adeboye, who is the storm officer of the defendant when I was in the employment of the defendant, had a pin card which he updated daily to show the quality of material / consumable left in the store. In the event that the available material / consumable were no longer sufficient, it was the duty of Mr. Taiwo Adeboye to raise a request for restocking. End of quote. Paragraph 13 reads thus, and I quote, that I am not an engineer and I have never had any training nor presented myself as an engineer, and I was not employed by the defendant to handle, repair, or operate any of his machine. End of quote. Paragraph 14 reads thus, and I quote, that the defendant has both in-house and external engineers who effect necessary repairs of printing equipment and machines of the defendant, and who service and maintain them from time to time as the need arises. End of quote. Paragraph 15 reads thus, and I quote, that even though it is not my core duty as production manager, I did on many occasions go beyond my normal obligation to facilitate the work of the defendant engineer, just to ensure that operation in the production units / department, as well as defendant company contractual obligation and business fortune, did not suffer any setback. End of quote. Finally, paragraph 16 reads thus, and I quote, that on many occasions, I spent my personal fund to purchase items required for machine repairs because the defendant company group managing director neglected and or failed to make funds available. End of quote. In addition, CW1 stated under was examination inter alia thus, and I quote, can you tell this honorable court your educational background and qualification? What is your highest qualification? Answer, Master in Business Administration. End of quote. Therefore, from the totality of the evidence of CW1 before the court in defense of counterclaim, he led evidence that he is neither an engineer nor presented himself as such. To this extent, the onus is still on the defendant counterclaimer to prove negligence on the part of the claimant defendant to counterclaim. To this end, and without further ado, the defendant counterclaimer has failed to prove with credible evidence negligence on the part of the claimant defendant to counterclaim to warrant the grant of the counterclaim. On that note, I hereby resolve issue 2 against the defendant counterclaimer in favor of the claimant defendant to counterclaim, and hold very strongly that the defendant counterclaimer has failed to prove his counterclaim to be entitled to the grant of sale. In the final analysis, and for the avoidance of doubt, as well as the reason contained in this judgment, I hereby dismiss the claimant's suit in its entirety. The counterclaim is equally dismissed in its entirety. No order as to cause. Judgment enter accordingly.
We are grateful for that erudite judgment. Hello, sir. We are grateful for that erudite judgment.
Thank you.
And the industry. I'm sorry I went off at the time, but I couldn't reconnect. But I reconnect later, but I had the chunk part of the judgment. We are grateful, sir. Thank you.
Thank you.
My Lord, we are very grateful for the wisdom of the court, and we appreciate, my Lord, for the judgment, my Lord. We're very grateful, my Lord.
Who is speaking?
My Lord, this is Barrister Oluwatosin Olojo.
Are you for this matter?
Yes, my Lord. I announced my appearance earlier, my Lord.
Are you for this you appearing for who?
Yes, Olojo, my Lord.
Okay.
Yes, my Lord. We appreciate the wisdom of the court.
Somebody spoke earlier.
Okay, maybe the Learned Council spoke earlier, but since I appeared earlier, so that was why I had to talk.
Who spoke earlier for record, please? Who spoke
Well,
before you?
Isaac Abubakar for the claimant, sir.
Okay, well, let me put you on record. Initially, I put you absent.
Isaac Abubakar for the claimant.
You know what? Yes, sir. Yes, sir. You today? Thank you. Thank you.